My name is Jacqueline Kagume, and I work at the Institute of Economic Affairs. It is my pleasure to welcome you to the IE's 20th webinar of 2025 on the topic of today's discussion is the public policy lessons from the landmark case of the Owino Uhuru Supreme Court decision. So for those of you who have not interacted with the IEA before, the Institute of Economic Affairs is a public policy think tank, and our mission is to inform decision-making in Kenya, primarily through research, analysis, and dialogues on important questions of public policy and the economy. As part of our objectives, we seek to advance informed discourse on public affairs and also to raise public literacy on obviously topical public policy and economic policy issues. So we work across 6 program areas. We have a program on public finance management, which is our largest program, a program on economic regulation and competition policy, on futures and foresight, on international trade, on popular economics, and lastly, on the Constitution, Law, and Economy, which is the program where I work together with my colleague, Leo Kemboy. So again, as I mentioned, today we are having our 20th webinar of this year, and basically we are trying to unpack some public policy lessons from a recent landmark ruling. So the context, the very brief context to this is that we have a case here that was centered on lead poisoning in a low-income settlement somewhere in Mombasa County called the Owino Uhuru Village. And they filed a petition. Members of this community filed a petition against the company or the industry that had undertaken work, particularly related to the lead batteries smelting that caused significant poisoning and various detrimental health, environmental impact to the health of these members of this community. So in their petition, this petition obviously raised serious questions around constitutional rights violations, state accountability, environmental justice, and basically the limits of public redress in Kenya. So it also provided some important guidance in terms of the various rulings as it went across from the High Court to the Court of Appeal. And finally, what we have in the Supreme Court, it raised some important questions or insights into how public institutions respond to the needs of marginalized communities and the various tensions that exist between industrial activity and public health, and overall the role of courts in shaping administrative responsibility. So to help us, we consider this an important question of public policy as it raises significant constitutional law and constitutional violations issues. And so we prepared 2 presentations and invited an expert to also join us for our discussion today. So in terms of the presentations outlined for today, we'll begin with the public choice analysis, basically exploring how the incentives, power, and institutional behavior shaped the outcome of this case. And to make this first part of the presentation, we'll have Leo Kemboy, who is my colleague at the IEA. And then we'll have a second presentation where we are very privileged today to be joined by Professor Migai Akech, who is a lecturer at the University of Nairobi and also an advocate in the firm, Professor Migai and Associates firm. So we'll be hearing from Prof later in terms of basically the constitutional and administrative law lens to this discussion. So he'll help us to unpack the legal implications of this Supreme Court's ruling. So that stated, I'd like to go right into the discussion. Please feel free to ask any questions that you might have or that might arise from this discussion. And we'll also welcome your thoughts and feedback during the plenary session. We have a chat box facility on this platform, so you can note down your questions here, but I'll also allow you later to ask. So without any further ado, I'd like to invite Leo to make the first part of the presentation.
Called the Owino case is the decision, an appeal decision, a Supreme Court decision resulting from an appeal when Court of Appeal actually reversed the decision by High Court to restore environmental award that had been done for environment. And at the Supreme Court, that was a major fixture. This decision is very important because of three important issues. One, there is a problem of how industries are regulated in Kenya. Second is the way the state responds to complaints from the public. Third is, even though that a problem had already been cited and was subject of public affairs discussion in Kenya and subsequently parliamentary inquiry, nothing was done, that the community had to now come together and sue to ensure that those rights, constitutional rights, were preserved. The reason why it's also important, and the reason why Professor Migaya Cage, the inaugurated professor of law at the University of Nairobi, is here, is the principal question that it went now is, that was a question of determination in court, was what did the administrative state do? What did these agencies do? And then it went back in form of others saying we relied on documents from this agency, regulatory agency. So the question of the administrative law, Professor Migai will discuss with us, one of them being that principle of regularity, and the other questions now that what should administrative state do when people are faced with these challenges? So this policy brief is a context, an economist view of the discussion, and that discussion is, which is now, what is this? What are the economic policy questions from that? So we wanted to surface that, and that's why we've taken four approaches. One is what we call the public choice theory, and then the public goods theory, the environmental economics, and then the regulatory posture. So on public choice is just a fancy way of saying that every decision, some people act out of that benefit incurred on them, that benefit incurred to them. There's some benefit that you incur when you make certain decisions. And our understanding of this issue and the deliberations in court that and that now form part of the court decision is that individuals in government act in self-interest and not entirely in pursuit of that public good. And that public good is, in this case, was the issue of an healthy environment, ensuring that negative externalities, which in this case is the question of lead pollution, was addressed in the society, in that village. Third, in whatever way complaints that arise from that needed to have been done on that problems that deemed to arise whenever you are doing lead smelting should have been actually dealt with even before. These are preventive problems. This is not something that is a natural disaster or any form of a problem that will be an after solutions would be an afterthought. So some of these problems should have done. So in public choice theory, we see regulatory failures. Some of them, what NEMA officials, that those operations do not have proper EIA that there were illegal test runs, they failed enforcement. The promotion export promotion zones authority issued licenses without due diligence, and they relied on NEMA. And now that's where the question of presumption of regularity, which is that one state agency might not query the other. People say that that principle is that whether that state agency should review decisions of another state agency, especially if they have not followed due process. And then ministries of environment and health, reactive, but also politically expedient. And then the question of time inconsistent preferences. Because if the lead poisoning issue is, if once the environment has been poisoned by lead, part of it is people can't continue. No, life cannot be normal thereafter, even if once the ministry knows that that has happened, until an environmental restorative uh, program has been done. But that continued, and then the court assigned. So there's a problem of regulatory failure and self. What you see from the public choice takeaway from this is we see a problem of self-inflicted bureaucracy. Now, the the reason why we are here and discussing this court decision is because there was a collective action. Some CBO working in within that area came up together, put up sued government to ensure that, because they saw that part of the problem is nobody was taking action. There was no action either from government to restore the environment, nor there was action to actually correct the problems of environment, or in the court decision, a number 20 people cited to have died from that lead poisoning incident, and then there are other people who are affected because it's a public health crisis. That part of it is government coming now, admission of fault, and the other processes of compensation, and the other things taking place thereafter. So, uh, uh, so given that they are marginalized, that collective action, all of them coming up together to now work with this agency to sue, and uh, and so that shows the problem of collective action against private sector incentives. So the private sector incentive is that metal refinery and penguin paper, they cut compliance costs. Compliance costs in this case would be the things that they would have done to prevent that pollution. They externalize the cost of pollution to the general public, and that is profit maximization at public expense. And the court held them. So the problem that you see in summary from this is one part is there is a problem of political asymmetry. As a people, you are faced with a problem of pollution. On one side, there are other oversight institutions, including parliament. There are then regulatory agencies that are supposed to ensure that the licenses, the processes meet the conventional standards, and that no harm would be generated from this problem. And then you have the private sector incentive, which is maximization of output. So all these things clash together, and it creates a problem of that systemic failure, and that systemic failure is what resulted into now, which is the people of Owino Uhuru coming to court, and the judicial oversight is the last sort of resort to dealing with that kind of the problem. Now, a good environment, healthy environment is a public good, And it's a public good because it's non-excludable. Economists would say non-excludable to say that everyone benefits from those services. Uh, and it's non-rival because one person enjoying it does not diminish availability of others. That is an important element, and that's why we have specific agencies for regulation, including NEMA in this case, to ensure that that environmental protection, and which is also a right under the Bill of Rights, it's a right under the Constitution, and it's not just mentioned as a right to an individual, it's also mentioned as an obligation to the state. If you read, I think, Article 70 of the Constitution, that is a right that the state is supposed to ensure that healthy environment exists. Now, when state agencies issue licenses for this kind of an operation, it diminishes that right. It diminishes not just the public good, but it diminishes that right at individual level. And the state would be failing and actually culpable as they should. And that was the finding of the court on that it was not, they were not able to provide that. So that the lead pollution degraded those public goods. They shifted incentives. They profited, but shifted costs to residents. Public health crisis, deaths. People paid for deaths. And that's why we say the costs paid included severe health crisis, diseases, poor quality of life, and deaths, specifically deaths. Now, and then, and this is a problem largely of the failure of public institutions and externalities, because externalities need to be negative externalities are the only agency that can correct those externalities is the state, because that power, even the way the Constitution, it says the state shall ensure the state, that obligation is only under the state. So that agency, uh, uh, and that kind of suffering uh, is something that the state would be required to correct. Now, on the environmental economics, uh, the, you see the court, and this is just to mention in passing, we see the court recognizing those externalities and apportioning liability to those culpable parties, and they quantify damage, and then they awarded that global sum for the 450 households, and then abortion claim. And this is an important thing, because the other state agencies said the primary agency in charge of regulation actually we relied on those documents. But the court went back and looked at the scale of things and said that part of it is a problem cannot be exist and be systemic as such, even when it's gone through parliamentary inquiry, and these state agencies even gone through the entire process, and that these agencies were not able to deliberate. Now, in terms of the regulatory posture, it's just saying that it's weak enforcement. The problem of weak enforcement, uh, uh, weak surveillance, no meaningful complaint mechanisms. The complaint mechanism is just not, it's not a way to say, it's not just enough to say that you can complain that there's lead pollution. It would be meaningful if steps are taken to redress that problem. And then there are problems of uh, uh, minimal monitoring. Uh, but so, and these are problems that subsisted because of that low public trust, lack of political goodwill. Because once, especially at the parliamentary inquiry stage, even before these cases were filed in court, Parliament should have made a decision to do that program of environmental restoration effective immediately. At that time, even before people go to court to seek those rights. But you see that political goodwill, that political will to act and protect those constitutional rights led to judicial intervention. And that judicial intervention is that it takes time. There's a trade-off. It's a good thing, but there's a trade-off. And that's why we think institutions, all the institutions that were party to that case, including the county government, need to be alive to the fact that these decisions take time, but in the end, that justice would be served. So, judicial action is not systemic reform, but that systemic reform needs to come now from the way they approach the question. So, I'll discuss in the next slide before letting Prof come on board. So, one, the part of the systemic failure is that feedback mechanism. Feedback mechanisms, even where there is an error of omission, even where there is an unintended error, or the state should be able to correct those problems even before people seek that, and that's why we mentioned that admission of fault. That admission of fault is one way of rebuilding that credibility instead in the administrative state. But the second question that we see, and Prof will discuss that in detail, is that question of principle of regularity, which is that due diligence in government processes. One agency uh, uh, cannot actually make decisions on behalf of other governments because if you look even across the world, agencies and agency heads make decisions, and then subsequently the other agencies are supposed to confirm that whether that, for example, whether they are for example, for the case of Owino, Uhuru, even if a license had been issued, it's common sense and also part of administrative law that that liability and checking different agencies checking each other's decisions is an important element in ensuring that such outcome and such tragedies never occur again. And then again, incentives matter, and those need to be enforced into policy design. Was there regulatory capture? There is sufficient grounds to make that conclusion from that court decision. Uh, those hearings need to be public, and public in a way that it allows experts in that area, not just people from that locality, to have a say in some of these questions. And we can see the court decisions on Lamu call is an important element because not just one person in that area public participation is not just, and those hearings should not just be within that localities, opening up that process for even people who are experts. The big thing for me, and the reason why these agencies that were part of this court of the court case, is the robustness of that complaint mechanism. A complaint mechanism is part agencies should, as a matter of public policy, be able to take up to be able to take up complaints and address them in a meaningful way. And I think this is part of Kenya's original sin, which is uh, uh, that agencies just, so long as pressure is off, people just move on. Once it's not in public limelight, and if the residents of Owino Uhuru had not decided to go to court, I don't think we'd be having this discussion, or that environmental restorative program would now be enforced. And then environmental surveillance capability is a public good. It's tech surveillance, just, and you see it not just within from this Supreme Court decision, in many other areas, landfills, land. Uh, you see the river, people discharging effluent into the river. It takes time. It takes time until somebody starts to complain before those problems are addressed. That surveillance capability is something that needs to be as part of institutional reform for those agencies that are tasked with environmental surveillance. Another interesting part is the role of Attorney General. If you read the Constitution, the Attorney General is supposed to be the counsel for the Republic and especially deal with public interest questions. It's the office of the Attorney General is not an office of it's not the a government lawyer. It's not the ordinary it's not as reading in the Constitution 2010. It's not the ordinary government lawyer, the government counsel, whereby in any issue, if there is a clear example where the Attorney General, in enforcing public interest questions, should have admitted fault in court, uh, this is a very good instance, and actually provide counsel to government by requiring government to take uh, substantial administrative steps to correct the problem, but also form part of reform process. How do we ensure that this problem never exist, should never exist? Because this is not the in-house general counsel. This is the counsel for the lawyer for the republic. And part of the the thesis in question is that institutional autonomy and that institutional mandate for the attorney general to be able to stand for critical questions, especially where the cases of death, public health crisis, people measure, experts went to Owino, Uhuru, found out lead deposits even on ground. Those are things that part of it should have been addressed in its own. It doesn't need judicial oversight or the court to compel a government to be able to address that. Now, the biggest problem also is the reform of approach, the approach of parliament in dealing with these incidences. And that ties to the last question on this slide, which is fiscal policy. What is development? Because in Kenya, when we met in our daily interactions with policy, we see people seeing development as buildings, as roads, as other things. Development is also improving human development. That is I think the cornerstone of development is because you see it in policy that that is development. Development is not just, for example, uh, because we need exports or domestic industrial production at the expense of human welfare. That's a very important question. This is a problem at parliamentary inquiry stage. Fiscal policy should have come in and said, there's a cost here. Experts, what needs to be done? And then that cost is quantified and said, 1 billion shillings to correct this problem. A public health crisis, led experts. How do we correct this kind? So that is development. And I think the framing of fiscal policy around this area, Parliament should have used the tools. And given the fact that the Constitution under Chapter 12 provides powers of the past, and especially making budget outlays, Article 220 of the Constitution, uh, making budget outlays to uh, uh, that is something Parliament should have factored and corrected that problem. And as I wind up, this is a question of empathy. This is a question of uh, human dignity. This is a question that how can the world, how can the country that sense of responsibility. How can agencies in government exercise that sense of responsibility that ensures that they protect the lives of citizens that they look after? So thank you so much, Jack. Back to you.
Thank you. Thanks a lot, Leo. So we've had the economic analysis interpretation of this hearing and the ruling. And so we'd like now to move straight to the constitutional and administrative law perspective on the case. And to do that, we are joined, as I'd mentioned earlier, by Professor Migai Akech. So I'd like to invite you, Prof, to make your presentation. You're very welcome.
So I want to focus on the presumption of regularity as it was treated by the Supreme Court in this case. So I think the facts are important, particularly in terms of what NEMA and the EPZ authority did. So in February of 2008, NEMA had issued to Metal Refinery an environmental impact assessment license. That license had been given pursuant to an environmental impact assessment. And just so that I avoid saying that all the time, I'll just use the abbreviation EIA. It was done pursuant to an EIA project report that had been submitted by Metal Refinery in March of 2007. Okay? So, and then NEMA approved that project, and that project was to be undertaken in Kilifi district, not in Mombasa. But Metal Refinery then requested NEMA to change the address of the EIA license. NEMA obliged. NEMA authorized the Metal Refinery to continue its lead acid battery recycling operations in the Owino Uhuru village, indicating that an EIA license in respect of that parcel of land would be granted in due course. So in effect, NEMA allowed Metal Refinery to proceed with its operations without an EIA license and on premises that were not the subject of operations in the application that Metal Refinery had made to NEMA. And then to make matters worse, the EPZ authority issued Metal Refinery with an EPZ license in respect of the Mombasa land parcel, situated in the Owino Uhuru village in December of 2006. This is before the EIA processes were initiated before NEMA. And the EPZ authority was acting on the strength only of letters from NEMA. And those letters were in respect of operations that were to be undertaken in Kilifi. But then, while NEMA was considering the EIA project report from Metal Refinery, NEMA issued a cessation and restoration order, directing Metal Refinery to cease operations and initiate an EIA study. The idea being that they wanted to facilitate an in-depth evaluation of the potential impacts of the project. But then within 3 weeks of this order, NEMA approved the project. And then in June 2007, NEMA grants Metal Refinery permission to carry out trial runs. And once the operations were underway, NEMA then issues improvement orders to Metal Refinery, although there was no evidence presented to the Supreme Court to demonstrate that Metal Refinery complied with those orders. So that is the context. And how does the presumption of regularity come in? It comes in because in the proceedings, and I've seen the the issues raised in the Court of Appeal, but I'll focus on what the Supreme Court says. So when the matter proceeds to the Supreme Court, the EPZ authority seeks to rely on this so-called presumption of regularity. It is saying that, you know, we don't bear the duty to investigate procedural lapses on the part of NEMA and the ministry as far as EIA licensing processes, or whether the project activities would be harmful to the environment and human health. That is not our responsibility. That is NEMA's responsibility. But the Supreme Court disagrees, and the Supreme Court reasons that the presumption of regularity does not host a state organ's responsibility to prove the administrative duties of another institution, when, in its opinion, it finds that such institution has not completed with due process. Now, the Supreme Court then determines that the EPZ Act, the EPZ Authority Act, imposes a duty on the authority to ensure that business entities that it licenses under the Act do not have adverse impacts on the environment. And as far as the Supreme Court then is concerned, it is saying that the EPZ authority assumed the legal risk and responsibility for any shortcoming by NEMA in its process of issuance of the EIA license to metal refineries. And so what are the public implications, public policy implications of what the Supreme Court is saying? So what I'm trying to do is look at this presumption of regularity in the context of environmental governance in Kenya. And unfortunately, I did a study as part of a book on administrative law that Strathmore University published in 2006. And that book has a chapter on administering the environmental regime. And that book reviewed from an empirical perspective how NEMA carries out its legislative, constitutional and legislative mandate. And fortunately, I did quite a bit of empirical work observing, among others, environmental impact assessment approval processes that were ongoing at the time. So I'm going to place it in that context. And for me, I think the presumption of regularity is a fairy tale. And I'm saying it's a fairy tale because of the widespread non-observance of procedural requirements and principles in the administration of Kenya's environmental impact assessment regime. That is what I found, and I'll give you a bit more details from my empirical work. And that was 10 years ago. And I am shocked that not much seems to have changed. NEMA is as negligent as it has ever been. And so there's then a dilemma that is presented by what the Supreme Court is saying, because the Supreme Court is basically saying that there's a dual regime for ensuring that there is protection of the environment as far as these development projects are concerned. It is saying that not just NEMA, but the EPZ authority have duties to ensure environmental sustainability. Here's a dilemma for authorities such as the EPZ authority that are required to issue licenses only after applicants have obtained other licenses. In this case, the EIA licenses from other government agencies. In this case, it is NEMA. So on the one hand, what the Supreme Court decision means is that an agency such as the EPZ authority cannot base its licensing decision on the actions of NEMA or on the actions and decisions of NEMA alone. Such an agency has a duty to undertake, not only undertake a parallel environmental impact assessment process, but also supervise NEMA's EIA licensing and enforcement processes in terms of the issuance of the EIA license and monitoring compliance with the licensing conditionalities, because these licenses always come with conditionalities that have to be monitored. So that is on the one hand. But on the other hand, imagine the kind of inefficiencies these means practically in terms of the administration of the environmental impact assessment regime. Because now you have parallel licensing and monitoring regimes and processes. The question then would be, is that a prudent use of public resources? And also, what happens, for example, where the EPZ authority and NEMA, having established their respective licensing and monitoring regimes, arrive at different outcomes? How do we resolve these dilemma? I think that is a question that in plenary we should try and grapple with. But back to this so-called presumption of regularity, and why I think it is a fairy tale. So what is the presumption of regularity? The basic idea is that a court should believe what a government or a government agency tells it. We should assume that government agencies and the government itself, that their actions always have a valid rationale. So where a party challenges the validity of a document, such as an EIA license in judicial proceedings, then the court should assume that the document emerged from a process that we can safely rely upon to produce accurate information. Why? Because we assume it is transparent, it is accessible, and it is often familiar. But we should ask ourselves in terms of how the EIA regime in Kenya is administered. Is it in fact transparent? Is it accessible? Is it often familiar? So in other words, the claim from this presumption is that we should assume that the government agency that produced the document proceeded regularly. It proceeded in accordance with the applicable rules and principles. And so the effect is to narrow judicial scrutiny and widen the discretion of government and its agencies over decision-making processes and outcomes. The presumption is not based on facts. It is based on committee. It's based on inter-branch committee, in the sense that the rationale is that courts should credit the executive branch more readily than they would credit, for example, private actors or non-governmental actors. So the consequence is that in court, it will be harder for an individual or a non-governmental actor to prevail in court against the government. And that is why they say that to rebut the presumption, the court will require clear evidence to the contrary. And so in short, the presumption, like other presumptions, is just an aid to judicial reasoning. It's based on experience. It's based on experience that things will more often than not work in a particular way. It's not supported by empirical evidence. For example, that public employees as a whole are better. And I think that's why Leo was started off by telling us about public choice theory and the idea that individuals and governments act in self-interest. So we cannot assume that as a whole they are better, or for that matter worse, than the rest of us. And this presumption has found resonance quite in the United States, where courts have frequently deployed it. But it's deployed on the basis of circumstantial evidence that more often than not, government agencies will observe established procedural requirements. That is the assumption. So the question we should be asking ourselves, is it the case in Kenya that more often than not, in the environmental impact assessment regime, is it the case that more often than not, NEMA will observe establish procedural requirements. But even in the US, that has not always been the case. So in terms of how the doctrine has evolved, it's contextual. Sometimes courts are skeptical, sometimes they're not. In the New Deal era in the 1930s and early 40s, for example, when courts distrust for the executive branch was heightened because of perceptions or realities of executive overreach, the US Supreme Court thought that they would not enforce the presumption. They thought that it would be necessary, that judicial policing of internal agency processes would be necessary to protect values like due process, accountability, and the rule of law. And so, in short, what we should understand about the presumption of regularity is that it is not cast in stone, meaning that assessments of regularity should be contextual. And what does the Kenyan context tell us? As I've said, I've studied the EIA regime in practice. And what I've seen is widespread non-observance of procedural requirements and principles in the administration of that regime. And because of that, I do not think that courts should apply the presumption of regularity. And so in my study of the administration of Kenya's environmental regime, I made various findings. What are these findings? In many cases, NEMA fails to hold public hearings. NEMA issues EIA licenses after the commencement of projects. NEMA issues letters of approval pending the issuance of EIA licenses. NEMA issues letters of approval and EIA licenses contemporaneously. It issues licenses on the basis of project reports that are often faulty and do not contain sufficient information on likely environmental impacts. It disregards the advice of lead agencies. NEMA makes the majority of its licensing decisions on the basis of project reports only. And when it does that, effectively it precludes public participation. But even in the few cases where project reports, where NEMA requires project components or project proponents to undertake full environmental impact study reports, the paucity and complexity of the information available considerably limits the effectiveness of public participation. So in practice, and I observed one in respect of the Miwani Sugar Company, the public hearings that are held tend to be dominated by economic considerations. Is the local community going to get jobs? Environmental issues therefore receive very little ventilation. So in those circumstances, the question that I ask is, can we really argue that Kenya's environmental impact assessment license processes typically produce accurate information because they are transparent, accessible, or rule-based? I think the answer is no. So if the answer is no, then why would a court wish to rely on the presumption of regularity in such a context in which irregularities are the norm? And so it's understandable for me why the Supreme Court in Owino Uhuru is insisting that the presumption of regularity cannot come to the aid of the EPZ authority. It's only because the EPZ authority has a duty to ensure that its licensees do not cause adverse impacts on the environment, but also, as the Supreme Court reasons, the authority has assumed the legal risk and responsibility for shortcomings. And I'm getting towards the end, because then the question then is, the immediate implication of the Supreme Court's ruling is that we have a dual regime. And that because Kenya has a dual regime in which NEMA and the EPZ authority have duties to ensure sustainable management and conservation of the environment, the EPZ must probe NEMA's administrative duties. when in its opinion, it finds that NEMA has not complied with due process. The question is, how should NEMA then, the EPZ authority then go about undertaking this probe, forming opinions, and finding that the other agency, NEMA, has not complied with due process in its licensing and enforcement decision-making processes? So it seems to me that the only way for the EPZ authority to perform this responsibility imposed on it by the Supreme Court is to establish its own environmental impact licensing and enforcement regime. But the problem with an approach like that is that then we do have two regimes and processes. The question is that the best way to use our public resources? Yes, there's distrust that NEMA, or there is evidence that NEMA is not doing its job, but is the solution then to create someone else to do the job with NEMA and police NEMA as it does its job? And if you see the arguments, for example, NEMA was arguing in the Supreme Court that, and against the idea that the EPZ authority could rely on the presumption of regularity, NEMA was arguing that the EPZ authority could have outsourced experts or independent opinions if it lacked the capacity or the expertise to discharge its mandates. But I think that is problematic because this approach also elides the conflicts that will inevitably arise whenever the EPZ authority and NEMA or their experts arrive at different outcomes in their licensing and monitoring decision-making. If there are conflicts, for example, which agency then prevails in such a scenario? And look at it this way. If you look at the history of our environmental governance regime, it is built on the premise that we would create this agency called NEMA and that it would be the main administrative organ. It would work with other agencies, the so-called lead agencies that are specialists in their areas of expertise, for example, water or air, and that NEMA, as the main administrative organ, would exercise general supervision and coordination of all matters relating to the environment. If you look at it from that perspective, the Supreme Court imposing a duty on the EPZ authority to ensure its licensees do not cause environmental harm conflicts with NEMA's role under the Environmental Management and Coordination Act. In any case, when you look at the history, the EPZ Act was enacted prior to MCA. I believe that in such circumstances, the latter statute, which is MCA, would prevail in cases of conflict. And so to conclude, what then would be the solution in terms of giving practical effect to what the Supreme Court is telling us? I suppose that the solution would be for the Supreme Court to say, or for us to say, in terms of interpreting the Supreme Court's decision with respect to this presumption of regularity, is that a body such as the EPZ authority would fulfill its sustainable management and environmental conservation obligations by ensuring, or rather by issuing licenses only once it is satisfied that NEMA had adhered to its licensing and monitoring procedures. How would that work in practice? It would mean that the EPZ authority would have the limited role of, let's say it has a list of the things that NEMA should do, and then it would be ticking and saying, has this been done? Has a project report been issued? Has a public hearing been conducted? Has an EIA license been issued? In respect of which plot of land? Mombasa, not Kilifi. That kind of approach. Because I believe that way, we would be able to preserve NEMA's primacies as the main administrative organ while ensuring that the EPZ authority does not ignore or only pays lip service to its obligations, sustainable management and environmental conservation obligations. And that's why I'm saying, if you look at the missteps in the Owino Uhuru case, the procedural irregularities were glaring. And then you would ask, surely, even the EPZ authority should not have ignored those. What are those? Just to recap. One, it is relying on a letter from NEMA. That's as opposed to an EIA license. That's procedural irregularity number one. That letter has been issued in respect of a different parcel of land. Procedural irregularity number two. And then NEMA then gives conditional authorization for Metal Refinery to commence the project pending the issuance of an EIA license. If we were to take this approach, that would not happen, because the EPZ authority would tell NEMA that you cannot give a conditional authorization for this company to commence operations before you've issued an EIA license. Number three, NEMA did not issue a license, an EIA license, and allowed the project to proceed without one. Again, that is something that this oversight approach would prevent. And finally, in the absence of the EIA license, the implementation of the project was not monitored. And this is key, because it's not enough that an EIA license has been granted. An EIA license is always granted subject to certain conditions that have to be monitored. So the question then becomes one of the authority, again, using the checklist approach, from time to time, asking NEMA whether whether it has monitored and it is satisfied that the licensing conditions are being met while the project is ongoing and at the conclusion of the project. So if one were to accept this argument, then we would say that the EPZ authority fulfills its obligations by issuing a license only after NEMA issues its license in respect of the land in Mombasa, and that would require both entities, NEMA and the EPZ authority, to develop, I would believe, joint procedures for monitoring compliance with the EIA and EPZ licensing conditionalities, with NEMA as the primary agencies. Michelle, let me stop there.
So you've had, on the one hand, the economics, the economic analysis interpretation of this ruling, and on the other hand, very clearly you've had the legal side of it. And I will not attempt to recap, because I think they've done a good job at making the arguments. So at this point, I'd like to open up this session to plenary and invite you to comment on either of the presentations and ask a question if you have any. So I don't know who'd like to go first. Please raise your hand. I'll see it. If you'd like to seek a clarification from any of the speakers, please do so.
Thank you, Jackie, for the opportunity. Mine is not a question per se, but it's just a comment to my good friend, Professor M.A. I hear him make his submissions, and he points to some problematic findings that emanated from the problematic position that the Supreme Court ruling left us with respect to this particular case. So my comment or question would be, where does this leave us? Is there a possibility that any public-spirited actor can pursue can move the court to reconsider its own determination in a manner that does not leave us in a more worse position than we were before? And if that is a possibility, must this actor necessarily have to have been a party in the litigation, or any actor outside the litigation could be motivated or driven to move the court, the apex court, to reconsider some aspects of the decision that professors outlines as being problematic? I thank you.
Thank you. Thanks a lot, Duncan. Anyone else who would like to seek any clarifications or who would like to express any comments? Please do so. Let me see your hand. Okay, so then I see one. Oh, okay. Before I read what is on the chat box, I think I see another hand, actually two hands now. So I'd like to first invite Ahmed. Ahmed, please unmute yourself and let's hear your question.
All right, thank you so much to all the speakers and for that extensive analysis. My question is that now that this has exposed some sort of oversight in licensing, and how NEMA conducts its own its mandate as under the MCA Act, my question would be: does this now give us bring another window of how of how state agencies in Kenya conduct its mandate? And how can we use this as an example to now look at other state agencies in how they conduct their mandates and ensure that they are able to adhere to the standards that are within maybe the constitution or those laws that has established them? Thank you.
All right. Yes, thanks, Ahmed. Mary, your hand is also up. So please unmute yourself and let's hear you.
Thank you, Jacqueline. I think mine would be too concerned. Thank you. My question would be, then what is the place of environmental impact assessment in Kenya? Well, we are unable to get it right when it comes to execution and licensing. And when we talk about the NEMA factor, then as a body, because I had Professor alluding to the fact that we do not need another body to perform the same functions as NEMA. So does it really enjoy a monopoly in terms of its mandates? And what would be our honest solution, as Hamid has alluded to, in terms of functionality of NEMA? And do we have an oversight? Who checks the functionality of NEMA to confirm a few things, as the research from Prof has confirmed that they operate in a space where they do not really look into the proper reporting on licensing and giving leeways of the functions of different bodies within the environmental sector. And what is the place of corruption in all this? Do we have an oversight really on NEMA, so to speak? Thank you.
Thanks a lot. I think that's very clear. So far we have 3 questions, and there's 2 comments on the chat box. So Jaira says, now that the case has been referred back to the original court, do we have timelines for such cases to be decided within the shortest time possible? Because the case has already dragged for almost 10 years. So it's only specific, okay, Leo and Prof can comment on that, on the specific elements of the case that have been referred back to the environmental court. And then Eric also asks, those are powerful presentations. Perhaps I followed Prof's presentation because of familiarity. Okay. Are we able to get PDF copies of the presentations? Yes, for the CLE presentation that was made by Leo, you'll definitely be able to get it after this, posted on our website. So let's go to the responses now. Before I ask later for some final questions. So I'll start with Leo. Leo, if you have any comments, I know the bulk of the comments were to Professor. So Leo, please unmute yourself and see what you can respond to before I allow Prof to go.
Yes, so I'll answer the question of what the place of corruption, and then the other thing on given the finding of the court from Halim, what needs to be the findings, what needs to be done. So one thing that, and we started because by using public choice, that this and Prof will come in on the other issue. The public choice question is very important in how, as professionals, we understand public affairs in Kenya. You have to know that incentives that guide public policy makers on how they view things, whether how they issue licenses, how they issue all manner of things. That's why in economics there's something called rent seeking, which is now people are extracting rents from economic decisions. So that needs to have a kind of oversight, and that's why Parliament needs to have a view on how they're able to look into processes of regulatory agencies from time to time. One mechanism can be used to evaluate NEMA's decisions, especially in some cases where, as this case shows, that those licenses or any form of approval should have not been issued in the first place, as explained by Prof. On the other question is, what is that public policy? What is that public policy discussion that needs to happen? So the key question is, first, outside resolving that principle of regularity, is a decision needs to be made by Parliament to be able to to be able to especially in where there are many other agencies in together. What precedents need to be followed? Do we go by each agency checking its own decisions, checking the decisions of the others, or in a way that allows some sort of supervision or some sort of autonomy or some form of oversight that can cure that problem? And I think that Parliament, this question needs to go back to Parliament in a way that would solve the uncertainty problem, because that uncertainty is evident. Thank you, Prof.
Yes, Prof, you can please respond to the remainder of the questions.
Thank you, Jacqueline. I don't know why my camera is not working, but I can be heard.
It's okay, just press
Anyways,
it.
let me start there with what Kibo is saying about what Parliament needs to do. I think this is a problem that Parliament created, because look, the EPZ Act was enacted in 1990. EMCA, the Environmental Management and Coordination Act, was enacted in 1999. Why didn't somebody say that, look, we seem to have a problem here. How do we resolve it? Because when you impose conservation and sustainable management on a body such as the EPZ authority, then it must build a framework, an institutional framework for doing it. The institutional framework is really just having an EIA process and an ERO, the Environmental Restoration Order process, which is what NEMA has. Short of that, then you say, look, so we've set up an overall body that is responsible for environmental conservation and sustainable management. We call it NEMA. Let NEMA then work with every other entity in as far as the activities of those entities have something to do with sustainable management or environmental conservation, for example, in the context of investment projects, like what Metal Refinery were doing here. But in practice, NEMA, as I've said, I think is very bad. In practice, environmental impact assessment in this country, I would be brave to say is useless. It does not work. And that is a problem. Look at all the irregularities that happened in this case. How did these things happen? And nobody seemed to care and look at the impact, including the many deaths. How did the processes are very, very elaborate. The environmental impact assessment process on paper is very elaborate. Why is it that it completely failed in this case? Because then somebody, we would then say that NEMA, because NEMA has failed, either we need to reform NEMA or find a way of oversighting NEMA. And that is why I'm saying, for example, in this context, how about having cooperative regulation in the sense that, in terms of enforcing what the Supreme Court is saying, that yes, let NEMA be the main entity, but other agencies such as the EPZ authority surely must have a role to play in terms of even just this checklist approach of asking, has this been done? Has that been done? Has an EIA license been issued? Is it in respect of the correct plot of land, etc.? Because when we do that, we're able to go back. This was very simple. Somebody could have simply gone back from the EPZ authority and told NEMA that, look, but what we're dealing with is a license that you issued in respect of Kilifi, not Mombasa. But recall that the EPZ authority itself has, even before these processes begin, has already issued a license in 2006. So it is also not off the hook. I think I've answered the questions. Is there any that I've not answered?
Yeah, I think you have answered.
I didn't hear him respond to my concern.
Okay, so Duncan, could you like to maybe just repeat your question so that he gets clarity on it? But I think you were asking where do we go from here? But maybe you can add clarify your question, then he can respond.
Yes, I'm aware that part of the findings that the court ordered that this matter be taken back to the original court, but the concern is the issues adjudicated by the Supreme Court are never appealable, but you can only approach the court to review their own findings. So is it possible that the aspects that are a bit problematic, as Prof says, could be reviewed within that context? And does it take only the actors who are part of the case as litigants to move the court, or even a public spirited litigant who is not a part of the court can approach the court in view of those concerns? Thank you.
All right, thanks. Professor Migai, please, you can respond to Duncan's question.
So Duncan, typically what happens when a court takes back aspects of a case to the lower court, it means that it does not have sufficient information to make a decision. So it is basically telling the lower court that please hear this aspect of the case. And I believe this one was on quantum issues of who pays water. Please just hear this aspect of the case and make a determination. So it does not open up the other issues for reconsideration. The only time that the Supreme Court is ever going to reconsider this issue is that if another case arises, goes up to the Supreme Court, and then it is able to revisit its decision in the Owino Uhuru case. So that opportunity does not exist, which is why the options we are left with is figuring out, number one, how do we interpret the Supreme Court decision so that we hold both entities, both government agencies, the EPZ authority and NEMA, to account for their sustainable management and environmental conservation obligations. That is number one. Number two, we can then go to Parliament and say, look, we seem to have a problem. NEMA is not working very well. There are agencies that whose actions or inactions are bound to affect the environment. How do we deal with it? Do we establish or mechanisms or a regime for cooperative regulation? And what would that look like? Perhaps then the EIA could help us by doing research on this subject and telling us what cooperative regulation, what a regime of cooperative regulation in line of the Supreme Court decision would look like. And then Eric, yes, I'm happy, Jacqueline, I'm happy to share a copy of the presentation.
Oh, awesome. Thank you very much.
Thank you, Prof. Thank you, Prof.
Yes. So because of time and because I don't see any further hands, I think we'll come to a conclusion of this meeting, but not before I ask for any final closing remarks. Leo, please go ahead in case there's any final closing remark you'd like to make. Yes.
Yeah. Regarding Jaira's question, I remember now that we didn't answer. What was sent back to the original court is now the supervision on. You look at that order 4. It's the question about that matter is being sent back to ELC in Mombasa to deal with the question of compliance with restoration orders. So in environmental science, that process of restoration would now be supervised by the court. Remember, part of the quantum, 1.3 billion, is going to for award of damages for loss and life and personal injury, but 700 million is going for now that environmental restoration, and that is a process that will take place. So that is what was referred back to the original court with that question, only that question, that compliance question. So in we will for me in conclusion, the problem and the biggest and all these other takeaways is that the problem of regulatory capture or the problem of one agency which is supposed to undertake a specific function but they don't end up ending it is is a question that still needs that evades Kenyans. And this is not just one area. There are many other areas where people have gone to courts on many other things. And this is something that I think the Justice Legal Affairs Committee in Parliament needs to take up and start thinking about the institutional design, because you end up with results that some tragedies that are unending. And even the way Parliament approached the issue when they did, because they did parliamentary inquiry, you can, if for that report, you can check the report by Honorable Amin Abdallah, the chairperson. When they went round and did that inquiry, that decision, that they were not able to form an approach that solved the policy design problem of how NEMA functions, but even take the process of through fiscal policy to restore the environment. So I think that is a question that needs, why is it that we have that kind of a systemic failure, that we have to wait for all this number of years for a court decision to take us back again to square one? Why is that? And that, I think, is something that as people work and know who are interested in policy should be able to deal with. So we look forward to work together to in this kind of environment. I've seen people in audiences from these offices. So we are open to treating it as a public policy question. And if you'd like to reach out together with the resource person, who is here, Professor Migai, to be able to make sense of this policy problem. Thank you so much, and Back to you, Jackie.
Yeah, thank you. Thanks a lot, Leo. Prof, would like to invite you to make your closing remarks.
Thank you, Jacqueline. Leo couldn't have expressed it better, and I agree with him entirely. We have a problem. For me, I was shocked at what I discovered when I did empirical work on the administration of Kenya's environmental impact assessment regime, because simply put, it does not work, and it does not work for various reasons. In terms of the regulatory capture, yes, but there is a lot of corruption among the actors, and I also think there's people don't understand the environmental impact assessment regime because of its complexity. And because I'm talking about the general public, because people don't quite understand, it's easy to manipulate them. Manipulate them in terms of, so if you go to a public hearing, the few that happen, it will be issues of, oh, will we get jobs? And once the conversation becomes about jobs for the local community, then questions of, oh, but how will this affect our health, etc., are completely ignored. So I think this is something that needs to be studied more keenly, and with a view to redesigning the environmental impact assessment, or let me say the environmental management regime. I think for me requires a total overhaul, because it's simply not working.